Saurabh, thank you very much for speaking to Mirror Now. Now, your first book, the book you edited, was a rather salaciously titled Sex and the Supreme Court. For this one, for the second one, the title is comparatively pretty plain and pragmatic. 15 judgments, cases that shaped India's financial landscape. Why do you specifically want to write about, financial judgments and not say something else, say not crime?
Right. You see, Sex and the Supreme Court, which was the salacious first book that I wrote about, sex and not in, was a matter of gender, sexuality. That is part of my activism that I do. But my day job, the one that brings the bacon in, what I go to court every day for, is financial law. I do commercial litigation, etc. And that I use to fund my activism. And that is something I absolutely adore and enjoy. People think it's a dry topic, but it is anything but dry. So I had unique amount of information, knowledge, which I thought was necessary to share with people. It's all well and good to say that people like to read about salacious topics, which they do, and hey, good for them. But it's important for a citizen to understand what truly actually affects them. And what really affects them in terms of their wallet and their money is more important than what affects them in terms of their interest in some matter that is happening in court.
Saurabh, you say in your book in the introduction that the Supreme Court, in its judgments, have reflected the trending ideology of the day. At one point, socialist, leftist, etc. Just talk to us about that and why the argument you make for it.
Look, I think some people believe that the courts are completely immune from the society they live in. And nothing could be further than the truth. It is obvious that the judges who are deciding this are a product of the very culture, very society in which they come from and which they're deciding about. And part of that is socio-political, part of it is also economic, right? So all judges have certain philosophies which they bring to the bench, which are a product of the times they live in. And we've seen that really in the last 70, 75 years of jurisprudence of the courts. So right shortly after independence, the judges were probably more upper caste, richer people, could come from zamindar families themselves, which they did, and therefore had a bias which was personal, which was more laissez-faire, more conservative, and more prone to protecting property rights as they felt. But then the winds of this country shifted. Obviously, at that time in the 50s, certain kind of Nehruvian, Fabian socialism gave way to the more hardcore left-wing ideology of Mrs. Gandhi. And even the judges seemed to move along with that ideology. And in the mid-70s, we had judges like Krishna Iyer, a very leftist judge, a member of the Communist Party of India, who was actually a minister before he became a judge of the Supreme Court. Very left-wing ideology. Then we had liberalization in the 90s, when there was a feeling that socialism wasn't working for the country. And with that, again, we had a series of judgments which moved more right-wing and allowing government the free play in its joints, the right to take decisions, for instance, on disinvestment and the like. Two more recently, we have judgments in the form of, say, the Insolvency and Bankruptcy Code, when the courts have recognized that the NPA crisis that is facing this country will threaten to bring down the entire edifice, not just of the banks and the financial institutions, but the entire economy. So Parliament enacted a law, IBC, and the courts upheld the law and seemed to work in a way which would further the common public interest. So, but that was also right-wing ideology, because that is capitalism at its best.
I'd once heard that Supreme Court judges don't read newspapers so that they don't get influenced by what is being said on the cases that they're sitting on or judging. Is that true? That's clearly not true then.
I don't think that is true at all.
I hope they're not watching TV debates though.
I'm sure they do. Not only TV debates, they probably also watch social media. They also read newspapers. But I think it's a wrong idea to say that judges should not read and familiarize themselves and acquaint themselves with what is happening. It is imperative for a judge to know what is happening. As it is, when you become a judge, you become cloistered. You are not supposed to meet people because they may influence you or otherwise. So your social circle becomes very narrow. If you don't know what is happening in the country at large, right, then you are so out of touch with the lives of those people you're deciding about, that you are sitting in your ivory towers and out comes a judgment which has no connection with the ground level reality, especially so in matters of financial judgments. Judges are required to display commercial good sense. Ultimately, you're taking a decision which will have an impact on business. So till you know what a business reality is, if you start giving judgments, so for instance, one judgment I've dealt with here is the 2G licenses, right? So the court felt that there was corruption in the grant of 2G licenses, that there should have been an auction rather than a simplicity giving of licenses. All right, that's probably a correct view, that there should have been an auction. But the judges were so far removed from the commercial reality of what the effect would be of their decision that they went and quashed all 122 licenses, right? Which set back India's telecom revolution by a decade. Not only that, it also adversely affected foreign investor sentiment, because a lot of people had bought these licenses not knowing how they had come about, right? They just bought the licenses as innocent parties. Next thing they know, the Supreme Court has cancelled the license without any regard to what impact that will have on the finance and the economics. So these are judges who probably did not read the pink papers. Maybe they should have read pink papers, and they would not have come out with a decision which adversely affects the economy.
So let's start at the beginning. Chapter 1 is the First Amendment. Now, maybe rooted in good intentions, but it left us with one fundamental right less, which is the right to property. Right. And you argue that it had a very far-reaching impact. Just explain that to us.
The First Amendment to the Constitution is unlike the American Constitution, where the First Amendment gave them all the rights. Our First Amendment took away a whole host of rights. In this book, I discuss just the issue of the property right being taken away. But when you read the First Amendment, it took away even the right to free speech and introduced reservations. So it was a composite amendment that took away a large number of fundamental rights. But just coming to this case, India in 1950, a very poor country, large number of landless peasants. There is zamindari. There was an obvious need to do away with zamindari and give the land in the hand of the tiller, right? So that you would not be landless laborers working on a measly wages. So the government came out with anti-zamindari legislation, where zamindaris were taken over and the land distributed to the people actually tilling it. In this, the question arose as to whether the compensation should be given to the zamindars or not, right? Because the government didn't have the money, really. We were a very poor country in 1950. So we didn't have the money to give to the zamindars. And so the legislation often provided that a very minuscule amount of compensation would be given to the zamindars. But when this matter and this legislation went and was challenged in court, the court struck it down, saying, no, this compensation is not adequate, and the scheme that you have of giving this compensation is constitutionally suspect and flawed. And it had a very immediate and a deep reaction in the Constituent Assembly. You know, the Constituent Assembly is which gave us the Constitution in 1950. The first elections to Parliament would have happened under our Constitution in 1951, which they did. The Constituent Assembly was so shocked by this judgment that they said, no, we can't wait till even the first elections. Let us not waste any time, and let's quickly amend the Constitution and take away the rights which form the basis of this judgment. So the First Amendment was formulated by the very people who gave us those rights. So Pandit Nehru, B.R. Ambedkar, all these great stalwarts who were otherwise, you thought, actually believed in fundamental rights. When it came actually to applying them and actually giving fundamental rights to the citizens, that's when they said, no, this is wrong. This is not what we imagined. And that just shows often politicians say one thing and do another, right? They'll give you something, but when it actually comes to its impact and it starts affecting them, that's when they say, no, this could never have been our intention. And that is why Pandit Nehru said, we gave ourselves a beautiful constitution, the lawyers purloined it, stole it. So this is something, one of the reasons I'm writing this book is to familiarize people with what the reality is and what their perception is. The two are quite different.
And just to be clear, the constitutional is still not safeguarding our right to property.
In fact, it has gone much further. So our right to property was slightly modified in 1950, then diluted repeatedly, till in 1978 it is buried completely. So we had two articles giving us a right to property in 1950, Article 31 and 19(1)(f), Both have now been removed from the constitution, and today under our constitution of India, we do not have a right to property. We only have something called Article 300A, which says your property can't be taken away without some process of law. So Parliament can enact legislation and take away the right to property. There is no constitutional protection of something as fundamental as your property. And that to me is shocking, because we are a capitalist society today. We may have the word socialist in our constitution. There may be socialist viewpoints in it, but fundamentally it's organized as a capitalist system. And you can't have a capitalist system which does not protect or at least realize the worth of property and give it some meaningful status.
You sort of dedicate a chapter in your book to women in the workplace, and you tell us the story of Bhavri Devi, a social worker from Rajasthan, who actually becomes the first mover, not some corporate head honcho, but a woman, half-literate woman from rural Rajasthan who becomes the first mover when it comes to securing women's rights in the workplace are concerned. That is when the Supreme Court had stepped in there to give us the Vishaka guidelines, and you say it's time for the Supreme Court probably to step in again.
Correct.
Why is that?
Well, I think we all know the story of how the Vishaka guidelines came. Bhavri Devi, this worker in Rajasthan, was assaulted for simply doing her job, right? She was gang raped. She was gang raped by a group of a different caste, upper caste men, and not allowed to do her job because she was trying to stop marriage of child marriage. She was trying to stop a child marriage. The people from the family did not like that, and they said, all right, we'll teach you a lesson and we will gang rape you. As though that's somehow, the enormity of this crime still shocks me till date, and the fact that we accepted it till the Supreme Court stepped in was an absolute shocker. But that says something about the state of our legal system and says something about our state as society. But be that as it may, the court said, all right, here is this woman only trying to do her job. And because of the fact that she was trying to do her job, she was gang raped. And then examined the law and said that we got freedom in 1950. We got a constitution which says you shall not discriminate on the ground of sex in 1950. But in 1990s, there was no protection to women whatsoever from sexual harassment at the workplace. The Parliament had not thought it fit to make any law. It was obvious that it was hurting companies financially as well, because there is a lot of research in this book which I have highlighted, which says that a company which has a toxic workplace culture, which does not respect women, and where there is sexual harassment, will perform typically below par, right? Partly because people will not want to join that company. Best talent will not want to go to work in a company where women are harassed. Certainly women will not want to go into that place and work. So it makes no financial sense for a company not to have its places or certain codes in place to ensure that there is no sexual harassment. Yet, because the very people who are doing the harassment, namely men at the top echelons of a company, are making those codes, they never made those codes, right? So it was the Supreme Court which had to step in and say that, hang on, our constitution is not a meaningless document, that there are these beautiful words in Article 14 and 15 about equality of sex and freedom of being able to work. They have to have a practical impact, right? So that is why the Supreme Court laid down the Vishaka guidelines, which said that there will not be a sexual harassment at the workplace, setting up committees in place, and said, we hope that soon Parliament will enact legislation. But of course, it took Parliament 15 years after the judgment to have the Prevention of Sexual Harassment at the Workplace Act, the POSH, as we say, in 2013, almost 15 years. But this piece of legislation has come as so deeply flawed that it has no practical impact, I think, on matters in relating to sexual harassment at the workplace. There is a chilling factor. So, for instance, the Act says that if a woman makes a false complaint, right, she will be liable to be prosecuted. That sends a message that women lie, right? Women often lie, and we can't trust women when they come out and make a statement. Now, I don't understand why we do not take at face value what a woman says. It is not as though of all the women who are working today in the organized sector, there is a flurry and non-stop complaints that are happening. Complaints sensational as they may be, are extremely few and far between. They're very, very rare, right? That shows that there is tremendous amount of underreporting that is happening, right? Because workplaces, we know, and you as a woman, and I know any woman who's actually tried to work, must have faced some kind of discrimination and harassment that need not be overtly sexual, but harassment by virtue of them being women, which is the definition of sexual harassment. So it's rampant, it is rampant, yet there are such few complaints, right? And then in a culture where there are such few complaints, where women are hesitant in making a complaint, you have a section which says that it's quite likely a woman is lying, so let's prosecute her. Shows the mindset of this law is not in the correct place, right? So that needs to change.
Saurabh, the first line of your book says, when you get up in the morning and read the newspapers, it's almost like the Supreme Court is running the country. Now, of course, there are questions of judicial overreach, etc. But the two areas you argue in your book where the Supreme Court has had absolutely no problem or hesitation stepping in is corruption and the environment. And the Supreme Court very often has become the battleground of man versus wild. That's what you call one of the chapters in your book. So many people could argue, and you argue this as well, that when it comes to matters relating to the environment, the approach has to be more nuanced, and maybe the Supreme Court doesn't have the language of nuance, and maybe the executive is better off dealing with issues like, say, for example, the Goa mining, the example that you cite in your book.
Correct. That's absolutely correct. It's not merely that the judiciary does not have the language. The judiciary does not have the powers also, right? The purse and the army belong to the executive and the legislature. What the court has is the protection of the constitution and its moral authority, right? The courts also have some very rough and ready tools to ensure that the constitution is protected. They can strike down legislation, they can ban things. Often they do set up committees, but that dehodes the constitutional language. So the courts don't also have the expertise or the wherewithal to understand what is the impact of their judgment going to be, something we just discussed earlier. So when it comes to the environment, there is a perception that the executive has given industry a free rein and they're not controlling industry at all. So what happens? The pendulum swings exactly the reverse, and the courts say, well, since the executive is not preserving the environment, we will step in and preserve the environment. How? By banning everything. Now that is also no solution, right? Permitting rampant mining and stopping all mining, neither are the perfect solutions.
But what about Delhi's pollution, for example? The Supreme Court has stepped in every year, said some nasty things to the government, and yet we are every October, November faced with what we are faced with. So by the end of it, you'd almost feel that the Supreme Court doesn't have a choice either than to step in and have these extreme reactions.
That's true, but the point is those extreme reactions also have a reaction themselves, right? So the court to be unconcerned about those reactions is not a correct thing. They must at least be aware that if we ban mining, this will happen. For instance, you gave the example of the pollution. Now, I think banning pollution or controlling pollution in Delhi is very much the job of the executive. And it's easy.
Which they failed at.
They failed at. I know it's very convenient also, Shreya, for the executive to pass the buck to the judiciary. It suits them. They say, we can't do anything. In any case, the matter is sub judice, the court is looking into it. So their failures are sort of hidden by the fact or by the cloak of judicial decision making, which is not a good thing at all, because then the court will take blame on itself for being unable to stop pollution, a matter for which the court is not competent, the court is not supposed to. The court is meant to be a creature of last resort. We have stopped asking our elected representatives as to why is pollution not improving. I think, for instance, at the first level, the court must say that if pollution does not improve within such and such time, which is your job, which is the mandate of the law, right? The Air Act, the Water Act, it's mandate of the law, we will put someone in jail for contempt of court. You figure out how to do it. If you don't do it, in you go for contempt of court. That is one way. So that will immediately put the fire under the pants of people who are supposed to be governing.
What about bitcoins? You dedicate a chapter to bitcoins in your book. What's the status of bitcoins in this country? The RBI bans it, the Supreme Court strikes down the ban, then there was some talk of a crypto bill which hasn't happened, and then now there is a 30% tax on the earnings of bitcoins. What's the status right now? Is it legal? Is it not legal?
Well, that's something I think even the finance minister probably does not know. There is a complete deer in the headlights approach when it comes to Bitcoin. They want to ban it, but they don't want to ban it because this is possibly the future. Bitcoin is based on blockchain technology, and blockchain technology is something that every country will need in the future, right? So they go ahead and ban the RBI in a economic surgical strike, overnight bans Bitcoin. The court then strikes it down on the ground, and there I think the court was right, saying that yes, there are problems with Bitcoin. RBI does have power to regulate Bitcoin because after all, Bitcoin is alternative to currency. It is alternative to currency over which RBI has no control. So if the economy is going up and down, the RBI can increase interest rates, decrease interest rates, and can control the economy. But if people start using Bitcoin, over which the RBI has no control, the economy will be unguided. And therefore, the court says, yes, RBI has the power.
My last few questions are going to be questions that you've probably been asked 500 times in the last 5 years, but I'll still ask them. You don't write about it in the book, but the reading down of Article 377 is something that you were involved in. Decriminalizing gay sex. In spirit, has the government accepted the reading down of Article 377? Because it seems it hasn't reflected in your case. I mean, the promise was what? Full personhood, full citizenship. In your case, that hasn't happened.
Correct. I think it's fair to say that the government went a way and not the whole way, right? To be a queer person, to be a gay man, lesbian, woman, trans, bisexual, it's more than just the ability to have sexual relationships with your loved one in the privacy of your bedroom. That's not what life means to any person, gay or straight. So when the Constitution promised and the judgment in Navte Johar 377 judgment promised full personhood, it said that we as a state will not discriminate against you on any count whatsoever. One is, of course, the actual narrow issue decided by the judgment, which is on criminalization of the sexual act. But there was also a promise that the judgment held. As you said, full personhood, equal citizenship, the fact that I as an Indian have all the same rights and abilities, opportunities that every other citizen has. So this was the promise, but it has not been fully fructified. And Shreya, I did not expect it to happen either, because it is a process, it is a transition. The government, every government, and I'm not going to be party political about this, because for instance, when the 2009 judgment came upholding the striking down Section 371 by the High Court, even at that point, the certain ministers in the then UPA were making a lot of noises about. So this seems to be, as a political class, there was a dislike of the queer community. But I must say that it changed by 2018 when the judgment came. So on issues of criminalization, there was a kind of a consensus. But I did not expect change to happen overnight, because there is a reaction inevitably. Government consists of many, many different people. There is a liberal viewpoint, and the same government will have a conservative viewpoint. And on this, I thought there would be more of a pushback, which I was not surprised by, that there would be a pushback. But I can tell you one thing, in the last 5 years, I have seen a change.
Let's just give our viewers some context. Your name was cleared for the Delhi High Court as a judge of the Delhi High Court 5 years ago, and the government has still been sitting on it. There has been no yes or no.
Right.
Yeah, and that is the context to the conversation we are having.
So my consent was sought to be made a judge of the High Court in the year 2017. It's only last year that the Supreme Court Collegium finally also approved that and sent it to the government. So first there was a delay of some 3.5 years in the Collegium level itself, right? They took a long, long time to decide and send my name forward to the government. And for the last year, the government has been sitting on it, right? So I think this is a case of both the judges as well as government being equally disinclined to take what I think would be a progressive decision on my candidature as a High Court judge. I have said this often and I say this again. To be a judge of the High Court is a calling. It is an act of public service. I am a very successful lawyer. I'm earning lots of money. To quit that to become a judge would be financially not a great idea for me. Life of a judge is very tough. The pay is poor, the work is hard, and the conditions of working of exclusion, social, are difficult. But yet a large number of people do that out of a sense of public service, right? So I thought, I had hoped the government would also realize that it is time we reflect the diversity of India on the bench. But I think that may be a step too soon, a step too far for this government. So I see changing. It won't happen overnight. It will take a lot of effort on the part of myself and you and other people who believe in justice, equality, freedom, love, empathy, and above all, the Constitution of India, right? So yes, I believe we will succeed one day. Whether I become a judge or not, I do not know. Will this country become a better place? I certainly know that.
I hope the next time we meet, you do become the first gay judge in this country.
Right? Even if I don't, if I can set the tone for the next person to become, that would be a great thing for me to do. You know, Rome was not built in a day.
I hope it happens in our lifetime.
Yes, I'm sure it will. I'm sure it will.
We'll leave it there. So good to chat. Thank you very much.
Thank you for having me very much.